I'll just start by welcome everyone to the 9th meeting of the Justice Subcommittee on Policing. Can I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. Can I say apologies have been received from Alison McInnes and Kevin Stewart, but we have robust members of the team here, and let's see if they keep up to that description. Our first item, which is the only item, is complaints and investigations. Very important, and we're going on till 2:15 if necessary. It sees the first of our 3 evidence sessions on the handling of complaints and investigations under the new policing arrangements. The session will focus in particular on complaints and investigations involving Police Scotland and the majority of its police officers. Complaints about senior officers are dealt with by the SPA, who will give evidence at our next meeting on 19 September. And in our final session on this topic of 3rd October, we'll take evidence from the Police Investigations and Review Commissioner, known to us all as PERC. Can I welcome to the meeting Superintendent Niven Rennie, Association of Scottish Police Superintendents, Deputy Chief Constable Neil Richardson, Designated Deputy for Chief Constable Police Scotland, and Callum Steele, General Secretary, Scottish Police Federation. And I don't think we're keeping just a we will keep about the rank and file police officers' complaints, but if you feel you want to say anything about the other system, don't feel inhibited. I'm sure you're not. John.
Thank you, Convener. Good afternoon, gentlemen, and thanks for the submissions we've had. We're into a new system. I had personal experience of 2 systems before, the discipline system and then the misconduct. I wonder if you could comment on the transitional arrangements between the 2, so between the misconduct and what we have now.
Yes, just self-nominate and your microphone will come on.
Okay. Happy to kick off. I guess from my perspective, in terms of the transition, this is probably one of the areas of activity within Police Scotland and the Legacy Force which has gone reasonably well. It's not clearly without challenges and questions, and you know, these I'm quite sure will continue as we move forward over the months and years to come. However, there was a very clear partnership approach adopted to this, with the individual component elements coming around the table, drawing on the good practice that existed from across 8 forces, drawing on the ongoing work that was taking place in the ACPOS arena to make sure that you know, lessons that had been learned from the past were picked up with this opportunity that presented to move into a single service. And the experience so far has been relatively smooth, I would suggest, from my perspective. There are a number of areas where we've got checks and balances in place, and I meet regularly with the staff associations so that we have an opportunity to compare notes, and if there are issues emerging, we get a chance to kind of identify that and hopefully intervene early. But in terms of the sort of the volume of complaints, the volume of activities, it has remained relatively consistent, and therefore there's no kind of warning bells ringing in terms of the sort of broader environment. So the general observation would be things have gone pretty well.
Anyone else wish to comment? Mr. Steele.
Thank you, Convener. I would probably, to a large extent, like to echo what Mr Richardson has said. The amendments that were made to the legislation for the 1st of April were largely technical in nature, just simply to reflect the fact that we're moving from 8 forces to 1. In the next few months, we're about to move to a new whole set of conduct processes, which in their own right will probably focus a lot of our attention on how we change our approach to misconduct and their investigations. But what I see as being a particular benefit for the new police service is the fact that whilst it is often the case that we tend to look at complaints about the police and the headlines they get as being focusing on bad and identifying bad behaviour and bad practice, what we are able to do by virtue of having a single service was we're also able to identify particularly good practice and particularly good approaches to addressing where there may be occasions of shortcoming. And as Deputy Chief Constable Richardson said, the fact that we are able to do that on a whole service basis with all of the associations and the management of the service getting together on a regular basis is definitely a good thing, whereas before we might have been following either good or bad practice around the 8 forces and dealing with issues almost like a ripple effect, where it starts in one area and over a period of time would make its way to another, whereas what we have now is certainly the opportunity to try and do it right first.
I don't really have anything to add to that. I think that's been quite comprehensive. We welcome the opportunity to meet with the Deputy Chief Constable to discuss individual matters of concern. That's been a very good development since the start of Police Scotland.
Yeah, thank you. The move in 1996 to misconduct regulations was supposed to remove the quasi-judicial approach that had been adopted and have a more managerial, I think was the term used, but they're still perceived as being fairly draconian by police officers because there are some severe penalties, and I suppose that's appropriate. Do you think there's sufficient understanding of the complaint system, particularly with regard to where allegations of criminality are inferred and there's an obligation on you, Mr Richardson, to forward information to the Fiscal Service?
I mean, I think there is an understanding. There's a frustration, it's fair to say, that we regularly are answering questions about the time it takes to go through the process, and there is no doubt that it is an unsettling and very difficult kind of time period for anybody that's subject to allegations. And so, I think that continues now, and in all probability will continue moving forward. But in terms of the understanding of the process and who has primacy and how that plays out, I think that there's a pretty well-recognised appreciation of that.
Okay. I think there's still an element that remains that some people have dealt with, the fact that you can still have two bites at cherry, that an officer can be found not guilty at court and still appear at misconduct hearing. Some occasions that may be appropriate. On other occasions, we've had some concerns about individuals that have been found in that circumstance.
Can I ask then, given what I said about the intended move from discipline to misconduct was to have a more managerial approach, with regard to service delivery issues, is it possible that a lighter touch could be taken? For instance, if someone were to, as a former councillor, to complain about a council vehicle parked on the pavement, the council might say to everyone, can you just be a wee bit careful? The experience with the police might be they would charge someone with a minor road traffic offence. Can we have a more measured response to some of the lower issues? Is that possible?
I mean, what I would say around that is that as my single priority, I guess, in terms of the transition was to achieve consistency across the country in practice. So even in areas where we're following sort of standard national guidelines, there were still differences in its application. And one of the areas where I've been pretty strong and as consistent as I've been able to be was around that very point. So I do not want to use the misconduct process as a tool. In a sense, I'm encouraging officers to act under their initiative. I completely recognise and accept that they are operating on their own with no supervision in difficult circumstances, and they need to take judgments. I cannot on one hand encourage risk-taking and judgment-taking under their own initiative if every time somebody actually makes an error, if I slam them with a misconduct book. So I'm acutely aware of that, and I've said on a number of occasions I will deliberately separate the two. So where it is obvious to me that an error of judgment has been made, or something has happened which might benefit from some corrective advice or some just a chat with a line manager, something along those lines, then that's exactly what we will do, and we are doing. There's probably scope to continue that standardisation, so there's probably more to be done there, but I think we're making pretty good inroads there.
Yes, I think, in fact, I don't think, I know Mr Finney's absolutely correct. In fact, in a past life, someone I used to work with once said that if the police service was a restaurant and you complained about the food, you'd end up sacking the waiter. The point of last delivery, which I think summed up an awful lot of individuals' attitudes towards how wrongdoing was perceived. It was the fault always fell at the last point of contact. But if I may just briefly return to the previous question as to whether the processes are properly understood, I actually don't believe that they are generally well understood. That's not to say they're not well understood by the service, because I believe that's absolutely the case. But I don't think that there is a widespread appreciation of the difference between misconduct and criminal inquiries and criminal investigations. For example, I'm regularly met by individuals that believe that when a police officer retires, which they're entitled to do, after having knocked their pan in for 25 or 30 years and many years after that, that when, if or when there happens to be any kind of complaint outstanding, that terminates in the point of retirement. Criminal inquiries go on regardless. I mean, we see that in all walks of life. And the suggestion, as tends to come up now and again, that police officers are retiring to avoid being investigated, I think is a widespread misunderstanding of what the difference in the processes are.
A final, if I may, Convener, thank you. Perhaps again to yourself, Mr. Richard or Mr. Rennie, could I commend the practice that one of your constituent forces had in the past, as well as publishing statistics about allegations of misconduct by officers? They also published the number of letters of appreciation that came in, which greatly outweighs and sometimes, I think, is lost in the way. Because if
so
some...
the MSPs could do with that as well, because somebody's got letters of thanks. Thin on the ground, but they're there.
I'm sure you take the point I'm making, Mr. Richard. The vast majority of officers go about their duties very diligently, and if someone takes the trouble to write a letter, you know, it's certainly worthy of recognition and would act as a counterbalance to some of the negative publicity, I think, that associates yourself with the rare occasions when officers do err.
I think you're not going to disagreement on that, are you?
No, absolutely not.
But we'll move on. Margaret.
Yeah. Good afternoon, gentlemen. I wonder, would you comment on the SPA's decision to instruct local commanders not to provide information about local police complaints to local authority police committees?
Well, who wants to take this on first? Yes, Mr. C.
I'm aware of the recent publicity surrounding this, and from recollection, and I know it wasn't that long ago, I'm pretty convinced that the Scottish Police Federation did have some concerns around the specific thing during the development of the Police and Fire Reform Scotland, as is now Act. And it was to do over, it was relative to where the locus or the responsibility for supervision or examination of complaints lay. And given the specific roles that are allocated now to local authorities and indeed to the Scottish Police Authority, we're very strongly of the view that it is entirely appropriate that local authorities are correct in being given information about service complaints and issues that genuinely fall within the kind of things that they would have a massive area of responsibility for developing in the local policing plans, for example. But I do not believe that it is appropriate that there is a whole-scale throwing open of examination of complaints of conduct or misconduct by police officers, because at the end of the day, that is not their role, it is not their function in terms of the Act. And whilst certain things that happened in the past might be nice to have, I don't believe they're necessarily essential. And if we consider, for example, a situation that might or may or may not be considered relevant just now, where we could have had someone on a local police board or authority who some years later turns out to have been investigated by the police for a number of deeds of misconduct, found themselves in criminal proceedings in court, whether it was appropriate for those individuals to be scrutinised in the actions of individual police officers who may have been investigating them.
I think there's a distinction to be made in the particular Fife case, which could well have been justified. I don't know the specific details, but it could be an unjustifiable intrusion. And this blanket instruction from SPA now not to provide even a bland figure. There have been so many police complaints in the local authority, which I think is then tipping the balance in the wrong direction, especially given, and it's my understanding, that SPA effectively investigates itself. Is that a reasonable assertion?
Given that I answered the last question, there is always the question, and this is one that we raised, and I actually think it was picked up on very sensibly by Mr. Pearson about who guards the guards, and and this was one of the things that we laboured at the beginning about the position of the authority. But you're always going to get that, you know, when you get in any hierarchical structure to an end point. You're always going to have someone at the top of the scrutiny chain being responsible for scrutinising themselves. You cannot have independence ad infinitum. But as to whether it will be appropriate, for authorities to be made aware of the general number, personally, whether that's useful or helpful or not, I don't know. But I would have no objection to that kind of information being made aware.
I think it's a matter for the authority to as a policy in that respect. But certainly, from my association's point of view, one of the big things about forming a national force was that we continued to engage with communities, that there would be a community confidence, and giving that sort of information to communities could do nothing but increase the confidence, the transparency that's available. So we would have no objection to that information being provided as well.
Mr. Richardson?
Yeah, I mean, obviously, the SPA, I know are coming to give evidence, and it's probably more relevant for them to offer specific answers to the questions. But, and without wishing to defend their position, my understanding of their position, particularly in relation to the Fife access to you know, specific complaints kind of position, was simply that nothing is written in stone, and we're more than happy to discuss the issue and refine our position moving forward if it appears necessary or desirable so to do. It seems to me there's probably a couple of things, and again, just coming at this from the position of having been involved in the restructuring of arrangements based on a mandate of considerable change. It's not reasonable to maintain and sustain the old ways of working as well as new ones. And so if under the old arrangements, for example, local authorities would routinely dip sample into complaints and satisfy themselves that there was a level of rigour and professionalism associated with them, if we were to continue that process, it would need to be maintained and managed, and that would take a sort of a resource implication that frankly is no longer in tune with the arrangements and the structures we currently have in place. So there is something there that we have to stand back and review in terms of the new arrangements where the SPA have responsibility for safeguarding the you know, public interest as far as complaints is concerned. But there is a principal point there, and in terms of complaints, for me that forms part of a number of indicators in terms of the quality and level of service that is being delivered into communities, and therefore as a suite of pieces of information that the community might legitimately ask for in order to gauge whether the services they're getting are at the appropriate standard. I don't think that's unreasonable. But again, that's part of an ongoing discussion in relation to local scrutiny committees, and as I say, I might have this wrong, but my understanding of the SPA position is that this will be refined moving forward in discussion with relevant interested parties.
Yeah, I think that's useful because the police view on this will obviously influence the SP when they come in, and I think it is fair that, say, a bland number is given. There's a balance between a snooper's charter and just giving an indication of how many of this is going up drastically every time you meet, then clearly there's a problem. An exaggerated example, but just something that adds to the clearness and accountability. Can I ask you, gentlemen, about the landmark decision yesterday in the Court of Session, which went against how a complaint was handled in Strathclyde Police because it wasn't ECHR compliant? And are you absolutely confident that the new arrangements put in, and we've already looked at SPA, which investigates itself, are all ECHR compliant?
I think that's one for you, Mr Richardson, as you've quoted in the press here, saying we are confident the structures and processes around complaints introduced are robust and do not require to be reviewed. Expand.
Well, indeed. I mean, I suppose my starting comment in relation to my my view of how things have gone is based around you know, the whole thing was structured around human rights and the public's need to value what we are doing and how we're doing it, and be comfortable and confident that that is acceptable, because at the end of the day, policing by consent depends on that. And so, you know, the safeguards that were put into place in terms of the creation of the park to make sure that clearly the legacy arrangements, if there was, for example, a police pursuit in an individual force, we would ask another force to investigate that on our behalf, and there was a level of separation, and again that was acceptable generally and regarded as such for many years. Clearly, when the 8 turned into 1, that was no longer possible unless you consider going down south, but because of the difference in the legal system and procedures and whatnot, that wasn't desirable, and therefore the park took on that and many other roles. Now, it seems to me that the concerns that emerged through that particular judgment were at the front of our thinking all the way through, certainly from our perspective, but also so too in the minds of government and park representatives and Crown. And where we've reached, I think, is a sensible set of arrangements that at this stage of the game seem to be working quite well, and there is nothing to give me any cause for concern that in any way the human rights position of this has been compromised as a consequence of the change.
Yeah, and certainly having introduced a members' debate which went against one proposal, which was to put complaints in with the Ombudsman, and then I'm delighted to see the Police Investigation Review Commissioner having been set up, and I think the independence is enshrined in that, but I still have a concern about SPA. Can I ask you, given that it's taken 9 years for this judgment to come, are we looking at a potential slopping out scenario where there are other cases going to be brought forward now that a precedent has been set?
I mean, this is how long is a piece of string, and I qualify what I'm about to say next by saying I am not a legally qualified individual, but there are potentially some difficulties lying ahead. I think the Ruddy judgment in its own right is massively important and will have lots of implications for the police service. There's no point pretending it won't. And anyone that starts by saying Ruddy's judgment and the credibility associated with independence of investigation, the fact that that's been questioned now, I think, will continue to be examined in some considerable detail. And it might well be that what we have with the creation of the Park Police Investigation and Review Commissioner was in itself a happy accident. But again, to reinforce the qualification that I am not a legally qualified individual, if the judgment in its own right raised questions over even the independence of a police force investigating another police force, I just wonder how much credence will be given to a police officer or a police force investigating its own, even if it's under the supervision of an independent body. I will be interested to see how that plays out. And with regards to the 9 years, I think you can blame the police for a lot, but we can't be blamed for the slowness of the judicial process.
I mean, it's an interesting comment by Mr. Seal, because in the press cutting we have from the Herald, it does say that the creation of PERC this year offers a more robust and independent complaints handling process. However, lawyers would be lawyers, believe it still falls short of being ECHR compliant because some initial complaints are still handled by police officers. I think a comment that you have made, so we just, I don't know if anybody wants to comment on that.
I think there's different categories of complaint. I think the more serious complaints are the ones that we really need to be having care how we deal with them. The general misconduct and low-level complaints can be dealt with quite quickly, and I think being quick in response to a complainer and giving them that level of satisfaction is important. But I think it's more complex complaints that we need to make sure we have an element of independence and that they stand up to scrutiny.
A lawyer might dispute the definition of complex and the impact it has in somebody's life. What might not be complex to officers, senior officers, might not be a big deal, is a big deal to the person at the front and have big impact on their life. So I think that there is an issue there. Graham.
Thanks, Convener. First of all, I would acknowledge it's a very difficult area, but as Callum, I think, alluded to during an earlier submission, it's a very important one in terms of confidence in the police. And there is, I think, an ignorance about how these systems work. So I do think there's a deal of work to be done there, and primarily, unfortunately, Mr. Richardson, it must be your work to advertise to the public how this works and what they can expect of it, and also to officers. Having been on the receiving end of process in a previous life, I know the impact it can have on their lives for a long, considerable period, and the vagueness with which a process is administered can just add to the anxiety of individual officers. If I come back to the point raised by Margaret Mitchell about this particular case, the nub of the matter seems to be the initial police investigation was conducted by an officer from the same force. And it would appear from the flowchart that the current process will likely maintain that there is only one force, and therefore the initial report in relation to a complaint will be similarly conducted. So given that you're confident, what made you confident? What actually did you hang your hat on and say, no, I think that we are now in a better position?
Sorry, with regard to what
the future handling of complaints and ensuring that no one could challenge the independence of the process.
Well, I certainly wouldn't be saying that nobody could challenge the I mean, people will
No, but
be
I'm saying
entitled
that
to their...
you say you've looked at the current setup and you're confident. What elements of this new process made you confident?
Well, what we have, I guess, that we didn't have before is the opportunity to develop a consistency and a single line of approach, which with a single service is achievable. With 8, it wasn't. And there were attempts, clearly. We had an ACPOS oversight committee that tried to share good practice and trying to make sure there was some level of consistency. However, the reality, as we know, was that, in fact, things played out very differently, and the parameters around where and when an individual was suspended looked very different in every force. The same on restricted duties and across the board. And so what we now have are a series of single standard national mechanisms in place that go up and include partner bodies. So we now have a CAP unit headed by Kate Frame that deals with all COPFS referrals that have got a criminal element to it. And so we have a single template for reporting. We are going through a kind of an education process so that officers involved in this domain across the country are familiar and aware of what is required. We've got a meeting coming up next week to talk about operational statements, which again is one of these things that is very mixed across the country, and we need to standardise that. So there's a number of things related to the process in a more general sense that we have still work to do, but we have an opportunity now to do it, and we've already got a number of things that I would suggest are now starting to become consistent that I think is a reason for confidence and optimism. In addition to that, around some of the stakeholder engagements, it's now far simpler. Yesterday I met with John McNeill and representatives from Crown, HMI, all the key stakeholders in the one room at the one time, and we are discussing the reality of the business that's flowing through, and where necessary we can make adjustments. And there were a number of actions that flowed from that meeting that I think are very sensible and will really help us to take the learning so far, 5 and a bit months into Police Scotland, and then refine the processes moving forward. Now, if I think about that experience in 5 and a bit months compared to what we did previously, I think there's reason to be optimistic about how we can now actually pick up on good practice and make it happen straight away.
Okay. I don't think we can take this much further, because it's always difficult dealing with merely a media report which summarises some facts but maybe not all facts. I don't think consistency was actually the point at issue in that particular article, or good practice or learning. It was about the independence of the person who did the first report, and I think that will be something that you need to have a second look at. But given that you are confident, good luck with that confidence in the future. Can I deal with some fairly mundane but practical issues which will help in public understanding? We were lucky enough to get a flowchart supplied to us about how police complaints will be handled in the future, and it indicates that the second stage of the handling is the recording and initial assessment before deciding is it non-serious, serious or criminal. Could you rehearse for us what post will make that assessment? How will that be handled in the years ahead? Who does that?
Can I just ask before you do this? This is
Sure.
a good question, and again for public. Could you give an example of a non-serious allegation, a serious allegation, and something that's in between that's going to cause thought? Just so that we know, because
Yeah.
we've got the flow chart. That'd be helpful before you go on to...
Well, I was going to do it the other way about, but that's fine.
Well, I'm so sorry.
That's all right.
I thought we were working as a team,
We
Mr.
are.
Pearson. We are a team.
We are.
Right.
I guess, I mean, the sorts of things that generally fit into the quality of service bracket, where there might be a mixed perception. An officer might have, in an attempt to quell a situation, have been perceived by a member of the public as being overbearing or overzealous, or it's that type of thing, and therefore a complaint comes in. That would be potentially a misconduct matter, but in the grand scheme of things, probably relatively minor. The serious end would clearly be into, the kind of what I would term into corruption, where officers are using their office for means that are definitely with our expectation or our acceptable norms. So from the sublime to ridiculous, officers accepting money from serious organised crime groups, or indeed just accepting a free bag of chips because they're wearing a uniform, that actually fits broadly into quite a serious category.
What about the grey area? It's something that you would say would be, you'd have to really think about it. This is non-serious. I mean, you've said non-serious would be overzealous. When would that tip into, consider that might be a serious allegation? Just give it a flavour of it.
It's really difficult to answer that because it really does boil down to a subjective judgment, and all the cases are different. What we have in here, and it touches back on Graham's question, in really all cases that involve suspension or restricted duties, you have a single point of reference, and that's me. So we have staff within the complaints and conduct world, headed by a chief superintendent, and there will be various people that will formulate, sometimes using a strict kind of matrix, so that we look at various tipping points, and then reports would go up to Val McIntyre, as it currently is, the chief super of our PSD. And she would make a recommendation that would then come to me. And for everybody that they want to restrict duties for, or anybody that they are suggesting should be suspended, ultimately it will be me that takes these decisions. Now, that is in those circumstances, but in a similar way, Val McIntyre, as the head of this business kind of discipline, it takes a personal ownership of many of those judgments that fit into categories. Now, sometimes that is subjective, and you could look at the same circumstances and take a different view. I think that should be serious, minor, or whatever it might be. But for me, the bit that's more important is to provide a consistency so that the process that goes towards achieving these outcomes is common. And thereafter, yet mistakes might be made, or we might have sort of a difference of view. That can be picked up almost in a monitoring process, which we do as well. But on an ongoing basis, I am more likely to be able to reach a point of confidence to say, actually, I understand what these categories are, and I can then in turn report that to the police authority that are, again, still trying to find their feet in relation to some of these discussions, but are very active. And indeed, at the last police authority meeting, one of the actions was to set up a workshop, a bleak training day, so that on one hand, we could bring them up to speed with some of the things I'm now talking about, and at the other side, give them an opportunity to think through how they would wish to engage with some of that in a scrutiny kind of capacity, to give us checks and balances, and frankly, give me some level of assurance that somebody's checking my homework.
Yes, Graham, sorry.
Yeah. No, I think that's useful, and I think we've identified that your office, by the hands of your various servants, you make that decision about where these boundaries lie. Would you anticipate, as experience as single force develops, that although you'll never get a definition of these categories, you will be able to explain to the public where the boundaries may lie between each? I mean, the example you gave earlier seemed, we've got a non-serious one, and then the one about accepting the gift is certainly criminal. And it's the bit that I think Convener was interested in, between how do we get between non-serious and serious, which will be the real challenge. Would you see that as things develop in the coming year, you might be able to give some insight into how that is utilised within the force?
I mean, I think it does. It clearly, the more cases that we have, and we're going through the process, then it becomes clearer to the organisation generally. We also have an opportunity here with new conduct regulations coming through. We are in the process at the minute of planning a fairly considerable training exercise that will affect literally hundreds of officers within the service. That's an opportunity for us again as we go through that training to get some of these areas of clarity instilled within the organisation.
I think the public would find it helpful if they could refer to a site that indicates where some of these boundaries lie, so that if you're on the receiving end of something like this as a member of the public, initially you will see all as serious. But if you read some guidance and say, well, okay, I can see where these boundaries lie, it may be help with the handling in the future. I'll move on to...
Before you do, does anybody else, Mr Rennie? You look as if you want to come in.
Just having recently left a division where I was in charge of conduct, I think, adding to my previous answer as well, the vast majority of complaints that we receive at a divisional level are often ones where you can actually explain that the officer has made a mistake or this is the legislation that applies. So these would all tend to fall into the less serious category. And the point I was trying to make really was these are quite appropriate to be dealt with at a divisional level by a local inspector. Occasionally we have to go out and say, sorry, we got it wrong. But generally speaking, an explanation of why an officer acted in the way they did is suffice to satisfy the complainer's misunderstanding.
Again, for public knowledge, in those circumstances, will these events be recorded?
Every complaint is recorded and we send a letter back to the complainer also.
Again, a practical question. We received a summary of the various allegations that are pending, division and type and so forth. Although there's the various divisions listed there, at the bottom of the list there's something called special services. For the public record, could you explain what special services are? Because special services unfortunately collect a number of complaints within the category, and I'm sure that there'll be some devious answer in the public's mind, but it seems to me reasonably mundane in explanation. Could you give us what special services are, if you know?
I don't have reference to the document you're referring to, but I'm assuming...
We'll give you one. Can you get one? Spice briefing.
Not solely.
No, why I'm saying is this is a private paper, it's why it's not in the public domain,
Indeed.
but it's now in the public domain because you're asking the question, that's
Sure.
why you may now. We weren't functioning under some kind of special service here, I just have to tell you.
My assumption with that, given that it's territorial areas, that would be specialist services, I'm assuming, which is just officers that don't perhaps affiliate themselves to a geographical division, but nonetheless are in the public domain.
All forms of support agencies.
Correct.
Including maybe special service from CID side,
Yes.
dog branch, etc.
Exactly.
Yeah. It's just to clear any doubt in people's minds what that might refer to. My final question.
Of course, I've got John next.
Things are complex in this sphere and they've become all the more challenging with the SPA, Police Scotland, PERC. Do you feel, and it's really a question for yourself, Mr Richardson, because you have the responsibility here, do you feel that the boundaries between each of your responsibilities are beginning to clarify and that either now or very shortly in the future we will have an understanding of exactly where Police Scotland fit in the complaints and discipline process, where SPA fits and where PERC occupies a space in this regard, and not forgetting, of course, the Crown Office. Is there clarity in your mind how that's going to work?
It's extremely timely because I mentioned I was at a reference group yesterday and one of the subjects for discussion was that very point. So through the experience over the last little while, number of weeks, there's been one or two areas where it has, just by the process that's played through, it's raised question about activity that's taking place that's actually the responsibility of another agency. And I think what's happening is a couple of things, and again I'll remain positive about this because I think there's reason to be so. I think that clarity will settle down, and again it'll just be the examples that enable us, because having memorandums of understanding and all that sort of stuff are well and good, but it's not until you get into the thick of actually doing the business that these things materialise. So the first thing is I think some of the experiences are helping surface the areas to enable the discussion to take place. The second thing is I do have a confidence that we are meeting to discuss things. So instead of entrenching behind our organisational barriers, which you could easily have seen, again, in the name of independence, you could see that happening. But John McNeill chaired a meeting with Crown, with a number of us around the table, and again, it's in order to address these very issues, and there's some pretty constructive debate happening and actions flowing to enable us to firstly, I guess, deliver that clarity, and then look for ways in which any adjustments that need to be made are made without compromising the Crown's responsibility for criminal complaints, etc., but making sure that we understand what these interactions, and I don't think there's clean lines in any of this. I don't think there ever will be. I think it's a Venn diagram that we're talking about here, and there are overlaps in a Venn diagram. I only know this because my boys
I don't know if I can be bothered finding out what it is.
It's the one that he's recognised with the overlapping circles.
Oh, so like pies.
Indeed, yeah. and the areas of
Olympic
overlaps.
hoops or something. Yes,
Indeed.
I understand.
Others call it a fudge machine.
A fudge machine, yes, thank you.
Right, and in these areas, I think that they're always going to be there, but it's about recognising how we operate within that space.
But in time, I don't want to bolt you down to a day.
Clarifying that Margaret Mitchell not only knew what a Venn diagram was, she taught it.
Excellent.
This should have come to you first.
I don't seek to tie you down to a day, a week or a month, but in timescales, do you see clarity coming in place fairly quickly? The reason I'm pressing on this issue is that whilst there is some of these doubts within the process, it not only has an impact for the officers who will be complained against, because they'll be at some receiving end of that frustration and pensive thought. More importantly, I've got to say on behalf of the service as a member of the public, a member of the public could be damaged in the way the complaint is handled just because the authorities don't have clarity of purpose. And to leave a member of the public damaged for the rest of their lives feeling they were abused or let down by handling just because you're all going through this learning process is unacceptable, I would say. So do you see that this clarity will arrive fairly quickly, or are you virtually there now?
I mean, I think there's two sides to that. One is I think the clarity will emerge. So we have agreed before the end of the year to pull together a joint session where we're able to, through operating examples, work through those examples to dig underneath the MOUs that exist, for example, to get the clarity that we're talking about. And so I think that that's fine. But again, coming back to your point, whilst I share your concern and anxiety about making sure we don't let anybody down in any of the domains, I'm reasonably comfortable that the arrangements that are in place just now are unlikely to do that. So, the criminal investigation will have primacy, and there's no question about that. And in some of the inquiries that we're dealing with at the moment, the work is happening. It's not being delayed. It's not being slowed down. It's just in terms of potentially, the sequencing of things, which is more of a process issue, that we need to sharpen up on that. But the activity around, the investigation and progressing that, I'm not seeing glaring weaknesses in that at the moment.
Can I ask one last question?
You'll be peeved.
It's legacy I wanted to ask a question on. There were ongoing misconducts and complaints procedures within the 8 forces, and they weren't completed. Presumably handed over now to Police Scotland. Again, do you have a confidence that the current powers and opportunities that you have at your fingertips are sufficient and complete to enable you to resolve these pending issues, whether or not it's identified that a misconduct has occurred or that they should be closed? Has the system handed these legacy things over to you in a state that you can deal with?
I mean, I would say yes. I think what happened was the forces, they knew that the transfer was coming, and to be fair to them all, I think there was a very considerable amount of energy put into trying to shut down as many as they possibly could, so that it minimised the transfer. We are still dealing with some of those legacy issues, but they are, they're not high in number, and the ones that are there, as to the best of my knowledge, are being progressed without any, specific difficulties as a consequence of the changeover. Some of them are difficult issues, but they would be anyway.
I suppose the thing that worried me was that you're going to be in a position where you feel you don't have the authority any longer to deal with them. There's some fault in the way in which legislation has transferred these matters to you,
No.
or you felt that there was some kind of challenge that you would face if you tried to conclude them for good or evil? So
No.
you're happy?
No, I'm content.
I want to move on. I'm going to take John, but just very quickly, just to clarify, because it's been passed to me under Chapter 7, Section 45 of the Act, subsection 5, so it's 45 subsection. A local commander must mandatorily provide the local authority such, and subsection B, statistical information on complaints made about the police force in or the policing of its area. Now, from what you were saying, I take it what you were not talking about was actual files with data being exposed. Do I take it, therefore, that this is being provided, statistical information? You're nodding. What would happen if the statistical information was such that, by its very nature, it disclosed who that party was? It was such a small piece of statistical information. And what is that statistical information? Is it just numbers, or is it numbers plus, like you pursued with special and so on? Is it?
What we're talking about here is literally it's statistics. It's numbers. It would be virtually. Pardon?
Classifications of the nature of the complaints?
Yeah, it's a breakdown, specifically relating to their locality.
Would it be similar to the breakdown? Numbers and areas.
Yes, although it carries a lot more detail than that.
Does it?
There's a breakdown. Currently, it's in a consistent template, so all the areas are getting the same area at the moment.
Yes.
And it would
what
be
did that mean at the moment?
Well,
like that, you went sort of funny way with your head.
No, well, it might
like it wasn't going to continue.
Well, it might be enhanced as we move forward because there's specific requirements coming from areas. That's
you are on telly. The body language matters.
Yeah, it would be nigh on impossible to identify individuals, and if it did come down to
something that would.
Yeah, we would seek to make sure that that was appropriately anonymised.
Thank you. It was just a point of clarification now, John, and then we've got exactly 8 minutes. So it's John then.
Thank you, Convener.
Margaret.
A question for all of the panel. Something you said, Mr. Richardson, about a meeting next week, if I picked you up correctly. Now, the process, it's hugely important, clearly, that the public have confidence, and it's hugely important that your staff have confidence in it. And you said about consistency, and it may well have changed, and I appreciate knowledge is time limited, but my experience of, I think, assisting officers in 6 forces where they all operated entirely different systems, none more so than the issue of operational statements that you mentioned. Will clarification be obtained in that, and will that clarification say that they are ECHR compliant, for instance? Because it's very important that the officers who are affected by this understand that there's fairness being applied to them, as it quite rightly should apply to the public.
From my perspective, yes. My colleagues right and left would expect me to ensure that that was covered. One of the issues that's playing out at the moment is a lack of appreciation by officers as to what their operational statements are being needed for, and thereafter are they likely to then compromise their position if they subsequently feature in a complaint or whatever else. And these are legitimate kind of questions, but if what they're doing is compromising the content of the operational statement in the first place, it becomes self-defeating. So if, for example, the PERC in progressing an inquiry seek to minimise the impact on the service by saying we'll not interview officers and take them off their duties for that, we'll simply ask for operational statements, but they're so bland they don't give them the information they require in order to progress their inquiry, then it's a waste of everybody's time. And so what we're seeking to do is just get an appreciation and understanding of what is an operational statement in this new world.
There's the balance with self-incrimination, of course.
Well, of course, yeah, that comes into it as well. And if there is going to be any kind of use of these, then again we would need to have a discussion with our colleagues to basically be absolutely clear how that's going to play through, what safeguards are there, which ones are not there. That's the discussion, and the starting of that discussion is next week.
And would you be looking in the staff associations to disseminate that information to their members, or would something go badged by all 3?
It's almost like you were in a meeting that we were all party to a few days ago, because that's the very thing that we were talking about. The issue of operational statements is, as you're obviously aware, massively complex, and I was going to say not help, but perhaps that in itself would not be helpful. Certainly influenced significantly by the Cadder judgment and what that meant for the issue of self-incrimination. And despite the fact that I believe it is only right that any employer should be able to ask of their employee what they've been doing because of the nature of the police service and the expectations placed upon the police service. I don't think that this is just an easy fix, as individuals might think, because of the very real issues that have been identified. And of course, we mustn't forget that there are millions of contacts with the police on an annual basis, and members of the public, and the number of complaints in their own right are small by comparison. And whilst, I suppose by the nature of any group that's looking at complaints, there is a propensity to focus on the negative, the bulk of what police officers do on a day-to-day basis results in no adverse comment or criticism whatsoever. But when it does, we have to make sure that they are treated fairly, because if you don't treat the police officers fairly, then you can see why individuals who are complaining about the police would take the view that if you don't treat your staff fairly, how can you expect the staff to treat the public fairly?
I wonder, Convener, could I ask that we be secure information on developments with that particular issue, because I think it is a pivotal part in the process. This is a system whereby officers are asked to account for their actions during any period, and that can be seen as influencing how complaints work.
To comment, Mr. Benny.
We certainly welcome the fact that we've been involved in this discussion, and obviously our roles protect our members.
Ask about the timescales for handling police complaints. The standing operating guidance is 3 days acknowledging to be dealt with within 56 days and a 6-stage process. Is that working well?
These things are all different, and some we manage to do within these timescales. Some are pretty complex inquiries that take longer, and you know, it's a mixed picture, is the truth of it. There is a desire to try and bring that time down, and so I know in discussions with Kate Frame, for example, there's a desire to get to a point where there's a consistent time frame for misconduct and criminal kind of work. For the initial investigation phase, which is a lot less than 56 days. I'm trying to remember what the actual figure is. I can't quite remember. It's 30 days, around and about there. So there's a desire to try and bring it down, but there's also a need to make sure that it's done properly and thoroughly and in line with other demands and whatnot. So there is a balancing point, and I think it's too early for me to make too many commitments around that. I'd like to let that run and then review it to see how we can improve on it.
Have any gone over the 56 days, and if so, is there a procedure for dealing with that?
Usually what happens on the lead-up is that we get reports to indicate that it's going to go over and give us the reasons why, and then we get into a sort of discussion around what that extended period is going to look like. There'll be none that we leave open-ended just to say, well, you know, just submit it when you can. So they are being monitored, managed and pushed, but if they are going over, there are usually pressing reasons why. It might be the availability of witnesses, it could be a range of things. But you know, I don't have statistics on that particular point, but there isn't something there which is a long list of cases which routinely go over.
Has there been anything learned from some of the complaints received that would improve the service? And if so, how do you communicate that?
Well, that's part of that almost a quality assurance process that, again, happened within legacy forces anyway, but we're now building that in so that every case, if there are learning points from that, we expect that to be fed through, and we get an opportunity on an ongoing basis to sit down and then review practice and policy based on experience.
When you say you expect that to be fed through, could you explain what you mean by that?
Well, each investigating officer's report will have recommendations, and it will have a narrative in it. If, as a consequence of going through the process, there are learning points that would benefit others, and that might relate to a change in procedure, a change of practice or whatever else, then my expectation is that that would be fed in through the inquiry officers, and then once it comes into the mechanics of the PSD world, there are others that are overviewing these reports, and again I would be expecting them to be feeding up to me and, you know, to Val's management group, basically, so that these things can be discussed on an ongoing basis. We have a very small number, in truth, of people who now carry pretty broad responsibility. So Val McIntyre, Chief Superintendent, carries that responsibility across Scotland. We have one person, a superintendent, who carries the misconduct responsibility and therefore has a high level of expertise and experience in that particular discipline. And effectively the same is true in a number of areas. That's what makes up the management team. So beneath these individuals there will be opportunities for them to pick up on the good practice from the last 4 months of experience and then feed that into the management process.
The local aspect is also important as well. I mean, a local management team monitors complaints. They're looking for trends, both in types of complaints received and behaviour of individual officers. And I mean, there's often good practice comes from that as well, to let all staff know about, you know, the throwaway line that's developing and address that quickly. So these issues are dealt with more locally.
Yeah, and just finally, Convener, the fact that it's going to the management team ensures that if it's good practice, then it's disseminated Police Scotland-wide.
Yeah, well, it gives us an opportunity to do that, yeah. Not to say, I mean, there'll be decisions and judgments taken on that, but yes, we have an opportunity to do that. And I don't think that opportunity existed before Police Scotland.
No, I don't think it did.
Can I just make an observation, and maybe a daft one, probably is, and I should stop myself right now, but in different parts of the country, the relationship between the police and local police and the way they behave with each other, the public police, will be different. And that what might be considered to be, you know, maybe unacceptable conduct at a very low level in one part wouldn't be in another part. You know the point I'm making? There may be a more familiarity in rural areas and a way of dealing with the public that's chatty and so on that might be seen elsewhere not to fit the thing. So what I'm asking really is that there's still a kind of flexibility for the relationships of police in different areas. Is that something that it's just daft I've thought about it, or that does happen?
It's a perfectly reasonable question. I mean, what happens at the moment for the high percentage of quality of service complaints and minor complaints is these are going to divisions to progress anyway. So they are centrally managed, so we collate, so we know how many and the progress of these things. But actually, the active management of them takes place at a local level. So if there were local geographic nuances that need to be factored in, they will be picked up because it will be the local officers that are largely progressing the engagement with the complainers and the individuals anyway.
So it wasn't so daft. I mean, there are, you know what I'm getting at, there are relationships that somebody might consider that, well, that's unacceptable, but in that particular area, it's okay, and it's not a breach of the professional conduct.
It goes slightly deeper than that as well. For example, sometimes the public have a very good perception of police from their regular contact, but when they're stopped by road policing for speeding and charged, they find a different attitude to the police officer, and quite often that leads to complaint. It's not how they expect a police officer to speak to them.
I understand that.
So our mailbag is full of such situations as well.
I think the point is perfectly well made, Convener, that the one thing that isn't standard on this earth is human beings. And if you try and apply a standard approach to human beings, you're never going to have happy outcomes. If we try and, or if the service tries to make sure that every single set of circumstances that any individual officer approaches is dealt with in a particular way, then woe betide us, because we're not going to do well. It used to be said that to err is human and to forgive is not forced policy. I certainly hope that we overcome that kind of attitude, which can still exist in a number of areas, despite the very best efforts of Mr Richards and indeed the very best efforts of the whole of the police service come the 1st of April.
Thank you. And a very short one, Graham, then we must go.
We've talked about all the circumstances of reporting. In a case that's non-criminal and is deemed to require a misconduct hearing, in the new process, who will chair that misconduct and how will the chair be chosen?
There will be a pool of people that are appropriately trained and experienced, so nobody will go straight in to chair something. They will have been a co-chair for a number of these things. And we will make sure that their skills are appropriately maintained moving forward. There's a reality around geography that means that we will need to make sure there's a spread and there'll be certain hubs across Scotland. But it will be effectively a small group of people that will be a rotating pool of individuals that will be drawn on. And that they will be selected through the sort of normal selection processes, that we don't have that many people in senior office at sort of chief superintendent level anyway. So,
So maintain as chief superintendent as the chair of the misconduct hearing, and there'll be a group of them around the country that you will decide to take.
Yeah, perhaps not exclusively chief superintendent. It may well be that we have superintendents doing it as well. But
So
it will be
superintendent rank.
Yeah.
Thank you.
I think we'd like to be kept up to date of progress with your VENs, and I am pretty certain they will move backwards and forwards. But, you know, when it's settled down, we accept this as a transitional period. But if keep the committee informed, and it'll also assist us when we take evidence in a fortnight's time, and then thereafter another fortnight. We've only got another 2 sessions on this. At the moment, nothing is set in stone. Thank you very much. Thank you.
Thank you.
The next meeting, before you all disappear, team, is on the 17th, 19th of September. Okay, same time, not necessarily the same place, and I close the meeting.